Assalamu alaikum, good evening. Welcome to another edition of Legal Ease, where we try to make the law as easy as possible for you, the viewer. We sort of, the legal jargon, we convert that into everyday English for you. We've been talking about employment law, we've been talking about dismissals, we've been talking about the bargaining council, we've spoke about employment equity in the workplace this evening. I've got a very important guest, Advocate Imtiaz Sirkot, and we'll be talking about employment relationship and the shackles of imprisonment. What happens sometimes, an employee is imprisoned awaiting trial, or even goes to trial, gets imprisoned. Employers often don't know what to do. Should they dismiss? Should they keep the position vacant? Should they hire somebody in their place? And we've got Imtiaz today to talk to us about this, what employers should do, what the employees' rights are. And viewers, after the ad break, we will invite you to call in if you have any questions, if you have any comments. But Imtiaz, thank you very much. Jazakallah for making yourself available, for coming here and talking to us about the employment relationship in the workplace.
Assalamu alaikum wa rahmatullahi wa barakatuh. Mohammed, thanks for having me.
Okay, let's kick off. I know you did a paper on this, you're the expert on this. And viewers, Imtiaz has been a part-time senior commissioner since the inception of the CCMA. He's also on the Tokiso panel. He chairs disciplinary hearings for employers. He assists parties at the CCMA, at bargaining councils. So he does various work in the employment relationship. But Imtiaz, today we want to concentrate on this, but we can talk about other dismissals as well. Tell us a bit about it. How does it work? What it's all about?
Okay, Mohammed, let me start by saying that employers often face the difficult question of what to do when an employee is absent from the workplace for an extended period of time, for reasons beyond the employee's control. The best example is where the employee has been arrested for a criminal offense and is in prison, awaiting trial, or has been convicted. Now, there are two different scenarios that arise. The first one is where the employee fails to notify the employer of his whereabouts. And the second scenario is where the employee immediately notifies the employer that his whereabouts. Now, let's go back to the first one, where the employee has failed to notify the employer of his whereabouts. Now, you know as well as I do, when it comes to the contract of employment, the onus is on the employee to call the employer and notify the employer that he's not going to be at work.
Right.
Now, if he fails to do so, he's in breach of the contract of employment. Then the employer has certain rights that the employer can put in place, like having a disciplinary inquiry, calling the employee to order, either in the form of a charge based on absenteeism, because the employer is not aware of where the employee is, try to get hold of the employee, and there's no response.
Right.
Now, if the employer proceeds with an inquiry based on absenteeism, bear in mind when it comes to absenteeism, the discipline is progressive. You can't dismiss immediately.
Okay.
It comes with a warning, with the final warning, and then it ends in dismissal. Unless the employee has a very bad attendance record. If that's the case, and the employee has prior warnings, then the employee is entitled to dismiss. The employer also has other options. If the employer doesn't wish to proceed with charges of absenteeism, the employer can proceed with what we call abscondment.
All right.
Because the employee has been deviant and hasn't advised the employer as to where he is, abscondment is basically where the employer can draw an inference from the employee's absence that the employee has no intention to return to the workplace.
Okay.
And that can result in, if the employee is found guilty, can result in dismissal. The third category, where the employer can charge the employee with desertion. In other words, where the employee has disappeared, no contact, the employer has tried to phone the employee, left messages, etc., and there's no response. And desertion is quite serious as well, where the a finding of guilty can mean that the employee would be dismissed.
Okay, an important thing, you said the employee obviously has an obligation to inform the employer. But now the poor guy is imprisoned, he's locked up, maybe awaiting trial. He doesn't have access to a cell phone. He may have had access to making a phone call, phoned his lawyer, phoned his family. They don't have the employer's phone number. Now he sits there, he can't get hold of the employer. That can happen.
That's a possibility. In fact, there's a case in point, Trident Steel, where the employee had spent 2 months in prison, tried to contact the employer through his relatives, and there was a misunderstanding as to whether the employer got the message or not. The employer had a disciplinary inquiry based on absenteeism and dismissed the employee. So the employee went to the CCMA, declared a dispute. The commissioner reinstated the employee on the basis that this is not misconduct. Right? The employee had no control over the fact that he was incarcerated. There was nothing he could do about it. So the employee took the matter to the labor court, and the judge made a very interesting finding. Besides upholding the findings of the commissioner, the judge went one step further and said, perhaps the employer should have retrenched the employee. Now that raises several questions. As you know, in terms of Section 189 of the Labor Relations Act, when it comes to retrenchment, you have to consult. How do you consult with an employee who's sitting in prison? And then it raises a further question. When it comes to Section 189.3, if you're going to declare the position redundant, it means the incumbent of the position is sitting in prison. The employer is now handicapped in the sense that he can't employ someone else in that position.
Because the position is redundant, it means there's
no longer
job,
exists. So that's not good sound advice for employees to follow, where you should retrench somebody, especially when they're in prison. But there's another case, Samanco versus MEIBC. MEIBC is the Metal Engineering Industries Bargaining Council, where, just briefly, the facts of the case. The employee was arrested for robbery, spent 137 days in jail. The first thing he did was inform the employer of his whereabouts. I'm in prison, please keep my job, and I'm out, I want to come back. And
so he fulfilled his obligation.
Absolutely. When he got back to work, they held a disciplinary inquiry where the employee was charged with absenteeism. Found not guilty, returned to work. 2 weeks later, he gets arrested again for robbery. This time, he spends 10 days at the police station. In his absence, now the employer is aware of where he is. In his absence, the employer has a disciplinary inquiry, the charge being operational incapacity. Dismisses him, sends him a letter saying, you're dismissed. However, you have the right, when you're released from custody, to come back to work, and we'll have a post-dismissal inquiry. So that's what happens. Employee comes back to work 10 days later, attends the hearing, gets dismissed again on the same charge, operational incapacity. The matter goes to the CCMA, and this is what becomes very interesting, where the commissioner says, if you look at the definition of incapacity, it only covers ill health, injury, and poor work performance. It does not cover operational incapacity. Therefore, the reason why the employee was dismissed was based on misconduct and not operational incapacity. The employee was reinstated. The dismissal was found to be substantively and procedurally unfair. Then the matter went a step further. The employer took the matter to the labor court. The labor court upheld the finding of the arbitrator and said, look, the arbitrator was correct. The decision cannot be faulted in any way. Operational incapacity does not exist in terms of the confinement of incapacity. Incapacity only relates to ill health, injury, or poor work performance. The employer was not happy. They took it further to the labor appeal court. The labor appeal court found in favor of the employer and said, no. The definition of incapacity can also cover operational incapacity. It can go one step further. So they found in favor of the employer. They found the dismissal to be substantively fair, but procedurally unfair, because the employee was given two different disciplinary inquiries, And the chairperson for both inquiries was the same person.
Okay.
And he was granted 6 months compensation. But the matter didn't end there. The employee took the matter to the Supreme Court of Appeal.
Oh boy. Okay.
On the basis that this was unfair, the decision of the arbitrator should stand at the arbitration.
Yeah.
Now, the Supreme Court of Appeal found that the decision made by the arbitrator was one that you could not fault, and it is one that a reasonable decision maker could have made. So it upheld the decision of the arbitrator that the employee was dismissed for misconduct, and that should not have been the case, and the employee is reinstated with back pay.
Okay. Because it was an unfair dismissal.
Because it was unfair dismissal.
Imtiaz, just briefly, we've had this before, but since it's coming up, and there's always, when you have cases like this, it brings about a bit of confusion. So just in terms of what does the LRA say? Because we know the LRA say you can only dismiss for misconduct, incapacity, and operational requirements. Incapacity is either poor work performance or ill health, as you've said. So just explain to us the difference between incapacity, operational requirement, and misconduct, just so that the viewers can understand this reasoning of the court, because it seems like they're inventing something new, which says operational incapacity.
Yes, absolutely. It never existed before, operational incapacity. This is something new.
Yeah.
Now, if you look at the definition of incapacity, if you look at Schedule 8 of the Labour Relations Act, it defines incapacity as ill health, injury, or poor work performance. It goes no further.
Right.
That's the reason why the Commissioner said operational incapacity is not applicable and cannot fall within the definition of incapacity.
Because the LRA doesn't make provision.
Because the LRA does not make provision for it. It is something new.
Yeah.
But the LAC, the Labour Appeal Court, disagreed and said, no, we can go one step further and broaden the concept of incapacity. So now operational incapacity falls into the definition of incapacity, and the same principles operate. Principles like dismissal is the last resort. Principles like you need to look for alternative options before you resort to dismissal. Principles like the employee needs to be accommodated in alternative positions before considering dismissal. So the same principles operate.
Okay, appropriate time, viewers, for us to take an ad break. Please stay with us. After the ad break, please come back. Be ready with your questions. Be ready with your contributions. We will have the phone number on the screen for you to call if there's any questions you want to ask Imtiaz, and you can ask him about imprisonment of employees. You can ask him about misconduct of employees, incapacity, operational requirements, any form of dismissal, in fact. And if you have some other question in terms of labor law that is urgent, I'm sure Imtiaz wouldn't mind answering that question. Viewers, welcome back. Our guest this evening, Imtiaz Sirkot. We're talking about labor law, obviously. We're talking about what happens when an employee is imprisoned, and we're going to continue with that. But also, we will have the number on the screen. If you want to call in with your questions, please call in. The number will be displayed in a minute on the screen for you to call in. Imtiaz? We're talking about, there's the number on the screen, viewers. If you want to call in 011 086 7777, please feel free to call in with your comments, with your questions, anything you want to ask Imtiaz. If you've just joined us, he is an expert on labor law. Imtiaz, we're talking about this imprisonment, and there was a FNB case in 2017. I'm sure you're aware of that case. Can you sort of tell us a bit about that case? That should sort of add to what we discussed.
This FNB case has taken the whole thing one step further. This is a case where an employee was offered a job as a financial consultant selling the products of FNB.
Right.
On condition that he passed a Financial Services Board exam. Now, he wrote the exam 15 times.
Can I stop you? We've got a call on the line. Sorry to do this. Go ahead with your call. Assalamu alaikum. Good evening.
Good evening, sir. Thanks for your opportunity. I have a query. I have a colleague who's got a business, who in turn retrenched a group of employees.
Right.
However, the employees belong to a union.
Okay.
So thereafter, they launched a case in which they're now stating that this colleague of mine had dismissed them because they were part of a union. In actual fact, he actually did retrench them itself. Now, it makes it a bit more suspicious because that line in which he was producing clothing, he lost the contract for it. But now they've launched this case at the labor court, and obviously now it's costing quite a lot of time and money to defend this matter. It's just a matter of coincidence that these line of employees belong to that specific union. What sort of defenses can we offer him in order to basically bring out his case and let the judge see what it is in order for him to basically come out of this? Because they're actually claiming, I think, a couple of millions in this so-called dismissal. I'll listen over the phone.
Okay.
Also over the TV.
Okay, Jazakallah, thank you for your call, Imtiaz. You heard the question clear?
Look, one of the things that you can try is obviously bring the union in and try mediation to see whether you can resolve the matter. Get in an independent third party. Obviously, it's by agreement. The union has to agree as well. If the union doesn't agree, then you don't have a choice. You have to defend the matter in the labor court. Now, I'm assuming that you're using a legal representative because you say it costs quite a bit of money as well. So obviously, if you're using a lawyer, your lawyer will be able to put your case. Look, I'm not sure exactly at what stage. You haven't told us exactly what stage the matter is, whether it's been close to trial, whether the matter has been set down, or papers have been filed, etc. But I'm sure your lawyer will be able to give you the appropriate advice. Mohammed?
Yeah, but Imtiaz, an interesting thing here, he says they've been retrenched.
Yeah.
Right. They now saying, no, we were dismissed because we were union members. Okay, before you answer it, we'll have a chance to address it. We don't want to keep a caller on the line. There's another caller on the line, and we'll come back to this one as well. Assalamu alaikum. Good evening. Go ahead.
Walaikum salam.
Go ahead with your question.
I just want to find out, it's not with regard to a person in prison or anything.
All right.
But a person has had cancer, and she's got no leave left to her, and she's got to go to work. She's been having chemo and things like that.
Okay.
But she's not feeling 100% to be at work. So what is the legal recourse that she has to be able to be boarded or probably get more leave for treatment?
Okay.
Yeah. Look, it'll fall under incapacity because it's ill health. One of the things that she must check on is whether the company has a insurance. In other words, where you can apply to be legally boarded. That's the first thing you should do.
Boarded.
Yes. So check with the company whether they are insured. Most companies are. Big corporates normally are. So if she's...
Do you think it's,
yeah, sorry?
Do you think if it's what's this, a Tikweni municipality, would that be...
Yes, they would. They would have it. Yes, in fact, I've done some work for them. They would have insurance where you can claim to be legally boarded. So you need to check that with them.
Oh, she must just look if they've got if they've got insurance.
Yes, for employees to apply to be legally boarded, what you should do is go to the Human Resources Department.
Okay.
And they'll be able to confirm whether she can bring an application to be legally boarded, and they will help her to prepare the application.
She's actually 59, and so she can't retire early.
No, the age is irrelevant. It doesn't matter whether she's 59 or 40.
Yes,
if she
but
has
she's
some
got
kind of
leukemia.
illness, if she has some kind of illness and she's not able to work any longer, she can apply to be legally boarded. Obviously, the employer must support her application as well.
Okay, and obviously the doctors would also give her...
Yes, you need the input from the doctors as well, that she's unable to work.
Right.
And you need the medical certificates or from the specialist confirming that, which must be part of the application.
Okay. Do you know how long this process takes?
I must tell you, it takes quite some time. Huh? It could take anything between 3 to 6 months.
Because now she's had a treatment here in Durban, but she's got to go now to Pretoria.
Oh, I see.
And I don't know how they're going to give her leave from work.
Okay, it'll probably be unpaid leave.
Okay. All right. Jazakallah, I appreciate
Right,
that.
Jazakallah for your call.
Shukran.
Imtiaz, we were talking about the previous question, but there's another call on the line. Hello, Assalamu alaikum. Good evening.
Hi.
Go ahead with your question.
Yeah, I just want to find out, according to my nephew, he's been dismissed like 5 years ago.
Okay.
And he actually won, I think, a settlement. A settlement where they had to pay him like 10 months, magical or whatever. But so they never paid it, and then the employee actually reviewed it at the labor court.
Okay.
And it's 5 years already. What can you do now?
Sure, 5 years is a long time. Okay, so what you're saying to us, there was an arbitration. The arbitrator awarded 3-month compensations on the grounds that the dismissal was unfair. The employer was unhappy with the arbitrator. The employer then took the arbitrator on review, and that matter then goes to the labor court. But it seems a long time for them to wait. What can the employee do in a case like that?
Has the employer paid security? Because now they've taken the matter on review. When I say security, means the cost of the amount involved. You said 10 months, whatever the amount is. Let's assume it's 300,000. Has the employer paid security so that they're allowed to take it on review? Have they done that? Do you know?
They haven't paid anything.
Well, if you're using a lawyer, then the lawyer must approach the employer and say, look, if you're taking it on review, then you need to pay that security.
Yeah, but tell me, after 5 years, can you still be reinstated?
Well, you said the award is in his favor. I don't see any reason why not. In fact, after 5 years, whatever interest has accumulated on that amount, you'd be granted that interest as well.
Yeah, and if his reinstatement, can you get back pay?
Absolutely. I don't see any reason why not. If the arbitrator has ordered back pay, then the matter is now sitting at the labor court. The labor court will take into account the 5 years that the employee has already lost.
Yeah.
So you won't be, your nephew is not going to be prejudiced in any way financially.
Okay, he just needs to make sure he has a good lawyer, a lawyer that understands labor law. Unfortunately, sometimes people go to lawyers
I think he doesn't. Everyone that understands.
Well, then maybe it's time for you to change your lawyer.
Trust, right? You know, like the company trust where is the beneficiary.
Yeah.
Well, if you're not happy with the lawyer, then maybe you should take the file and go and see another lawyer.
Another lawyer.
Yeah, take the file away from the lawyer, go to another lawyer that you're comfortable with, and ask him to proceed with the matter.
Okay, so you can actually get reinstated after 5 years.
Absolutely, I don't see any reason why not.
Because the money is still owing for it.
Yeah.
Yeah, and then the trust, how does the trust, you know, if you're a beneficiary, you know those trusts, company trusts. If you're a beneficiary, how does it work when it comes to like reinstatement?
Well, the trust has got nothing to do with it.
It won't affect this particular case.
Yeah, because you know the company trust was a beneficiary, so when they dismissed him, they probably take him off as a beneficiary as well.
No,
Well, it just depends who the employer was, because the employer is the person that is taken to the arbitration, and the employer is liable for the payment.
you must remember, because he was awarded reinstatement, he'll be put back in the position that he was in originally. So he's not going to suffer any loss financially.
Yeah, okay, so he actually was a settlement, so can we ask for reinstatement when it goes back to arbitration?
So, sorry, you said he took a settlement.
Yeah, but it got never paid.
Was it a settlement or was it an award by the arbitrator? Because if it's a settlement, then it can't be taken on review to the labor court.
No, it's an award by the arbitration. And the settlement was either reinstatement or 10 months salary.
Oh, I see. The award was settlement and back pay, you say?
Yeah.
Well, if the employee tries to defend it in the labor court and the award is in your favor from the labor court, a judgment in your favor, there's no reason why the employee can't go back to work and be reinstated.
Even if it's 5 years.
Yeah, even after 5 years. There are cases
so
where
is it going back to
employees have been
CCMA or
reinstated after 10 years.
Okay.
Where
So
the matter is
because-
sitting in the labor court, goes to the labor appeal court, sometimes ends up in the constitutional court, which takes a long period of time. But there's no reason why after a period of time, whether it's 5 years, whether it's 10 years, the employee can still be reinstated.
Okay, so the point is make sure you got a good lawyer who will know what to do and proceed with that. And on that point, I think it's time for us to take another ad break. Please stay with us. Come back after the break. If you have any questions, any queries, any comments that you want to add, Imtiaz will be here. Assalamu alaikum, good evening, welcome back. If you've just joined us, we've got Advocate Imtiaz Sirkot with us here answering your questions on dismissals, on imprisonment of employees. Imtiaz, one of the callers who he said employees are claiming that the employer dismissed them because they belong to the union, and we haven't finished that. That will obviously, in terms of the law, would be an automatically unfair dismissal.
Yeah.
The onus then is on
Shifts.
the employees to
Yes,
prove.
absolutely.
Could you talk to us about
Yes,
that?
absolutely. In this case, because the union is making that claim that they were retrenched because they were union employees, union members,
Yeah.
the onus will shift on the union to prove that the dismissal is automatically fair,
Okay.
unfair.
Right.
So the employer has to sit back and let the union prove
Yeah.
that it's automatically unfair
Okay.
before you put any kind of defense.
And that's a case that will go to the labor court,
It
not
goes to
arbitration.
labor court. Yes, not arbitration. It goes to
And
labor court.
similar to big retrenchment, would go to the labor court as
Yes,
well.
absolutely.
Okay, so here the employer says, if that viewer is still on the line, the employer says it's a retrenchment, but now the employees, and in terms of the law, employee determines what the dispute is.
Employee.
Okay, and the employee says, because we were union members, the employer is dismissing us.
Yes, you must remember that the employee, the applicant or the union representing the employee will decide on the nature of the dispute. They will in fact categorize the nature of the dispute. So if the union says they were retrenched because they are union members, then the onus is on the union to prove that the dismissal is automatically unfair.
Okay, and that the reason was because of
Yes,
their union.
the union is
membership.
because they were union members. That's the reason why they were retrenched.
Okay, before that caller called in, we were talking about the FNB 2017 case.
Before we move to the FNB case, in this retrenchment question that was put, the caller is still on the line. If the employer succeeds in proving that the retrenchment is genuine, in other words, there's good financial reasons as to why the employees were retrenched, then the union doesn't have a case.
Yeah.
So I think the employer must focus on showing that the reason why the employees were retrenched is not because they were union members, it's because there were good financial reasons for doing so.
Okay. Because the employer is not denying. The employer says, yes, we dismissed. Yes, it was a retrenchment. We were forced to dismiss because of the retrenchment. Okay, the FNB case 2017, you were busy with that.
Yes.
I stopped you, interrupted you, and sorry for that, but we don't want to keep the viewers waiting.
The FNB case is a 2017 labor court case. What happened here was the employee was offered a position with FNB, provided he passed a regulatory board exam set by the Financial Services Board. He wrote the exam, failed 15 times.
Okay.
FNB put him on the spot and said, look, you can't do this job because there's a legal impediment. If you don't pass the exams, you can't be a financial consultant. Therefore, we're going to allow you to apply for other positions. He did so, was unsuccessful. FNB had a hearing, dismissed him on the basis of what we call now legal incapacity.
Okay.
This is now an extension of operational incapacity, a different form of incapacity.
And it's not poor work performance, it's not incapacity due to ill health or injury.
Yes.
It's a different category.
So when he went to the CCMA, the guy was dismissed, the employee was dismissed. So he went to the CCMA the Commissioner found that the dismissal was unfair, procedurally and substantively, on the basis that legal incapacity doesn't fall within the confines of incapacity in terms of Schedule 8 of the Labour Relations Act.
I need to stop you there again. We've got a call on the line. Assalamu alaikum, good evening. Go ahead with your question. Hello?
Hello.
Wa alaikum salam. Your question?
Yes, speaking to Dan. Yes, I took the matter to the CMA.
Could you please speak a bit louder? We're not getting you clearly.
I took the matter. I was retrenched by the agent, the labor broker, and at the same time with the employee. So I took the matter to the CMA, and then the CMA took it to labor court.
Okay.
So at the labor court, the judge said I didn't have a lawyer, so they said we must make a settlement agreement. So on the settlement agreement, they said they will reinstate the applicant, and then they will recognize the applicant status from 2016. But when I got back to work, they said I must start and sign contract for 3 months, and then they will make me permanent after 3 months. So I just want to know about that.
So my understanding is you did not get the money after 3 months. Is that what you're saying?
Now I'm working. I mean, in the settlement agreement,
Yes.
they said they will recognize the applicant from status from the date of the infant from 2016. So when I report back at work, they just give me a contract for probation. They said they will take the applicant permanent.
So my understanding of what you're saying is the company has breached the agreement. Is that what you're saying?
Yes.
Oh, I see. Okay. What you must do is go back to the Labour Court, right?
Yes.
You must see the registrar of the Labour Court,
Yes.
right? And explain to her what happened regarding the agreement. She will refer you to someone in-house that will be able to assist you. There are attorneys who do work on a pro bono basis.
Yes.
They will give you advice. In fact, there's no charge as to what is the next step.
Thank you.
All right.
Okay, again, viewers, just to remind you, the number is 011-086-7777. Imtiaz, we keep getting caught up with callers while you're busy with the FNB 2017 case. You were almost done, but let's just come back to it in case you missed out.
So basically what the Commissioner said was that, it doesn't fall into the confines of incapacity. There's no such thing as legal incapacity. What the employer, FNB, should have done was retrenched, followed operational requirements, in other words, Section 189.
Right.
Should have retrenched the employee instead. So FNB took the matter to the Labour Court. The Labour Court followed the LAC decision, Labour Appeal Court decision, in the matter of Samanco, to say that like operational incapacity, legal incapacity is part and falls within the confines of incapacity as defined in Schedule 8.
Right.
So now that's also recognized, that for a legal impediment that's placed there by the employer and the employee doesn't comply, in other words, in this case where he failed the exams,
Right.
The employer has the right to terminate the contract of employment.
Okay, so now it's a new category again. So
So we're getting it's broadening each time.
right.
First, it was restricted to ill health, injury, and poor work performance. Now we have operational incapacity, and we now have legal incapacity.
Okay, and because the Labour Court or Labour Appeal Court or even a higher court made that ruling, arbitrators at the CCMA and the bargaining councils have to abide by that.
Yes, they're going to be forced to comply and follow the Labour Court judgments.
Okay, because judges make law. That's one of their
Absolutely,
functions.
which is good.
Yeah.
Because now we have certainty as to the way forward.
Okay. And often this happens. There's uncertainty in the law. Something new comes up, something that hasn't been tested. It gets tested at the court. Judge makes a ruling. And of course, now that is what happens.
Yes.
Okay. Let's come back to this imprisonment thing. Now we know that the employee, you said at the beginning, has an obligation to inform the employer. Employee cannot do that. But employers also have some obligation. I mean, we don't want to leave the employers with the impression that you don't have to do anything if the employee doesn't. Employer has an obligation to make a reasonable attempt to get hold of the employee. And on the show, we've spoken about that before. It could be a telegram. These days, it could be SMS. It could be WhatsApp. It could be any one of those things. But one of the things you raised is desertion.
Yeah.
And there's something else apart from desertion is the person absconds.
Yeah.
There's differences. One, you said the person doesn't intend coming back.
Yeah.
The other one, maybe the guy just wants to stay away for a while and come back. Can you talk to us about the difference between those two?
I think abscondment is where the employee gives the employer the impression that he doesn't want to return to work. In other words, an inference is drawn by the employer because of the duration of the absenteeism. Desertion is more expressly implied by the employee, where he empties his locker, takes all his stuff, and goes away. Okay. And the employer can...
So it's clear the intention is not coming back.
That, this is desertion, he doesn't want to come back, and then the employer can proceed with the hearing and dismiss on the basis of desertion because of the impression left by the employee.
Right. Okay, but the case where the employee just stays away for a few days, clearly tell the employer what must the employer do. Employer sends an SMS, then what? Because now the job is standing. Employer wants to hire somebody in that place. How should the employer go about doing that?
You see, the employer can't get away from the fact that we have a Labour Relations Act based on fairness and justice. The employer has to follow the principles of fairness and justice. In other words, you have to have a hearing. In other words, provide the employee with the opportunity to be heard from a procedural perspective. And if the employer makes the decision to dismiss or give a warning or whatever the case is, it must be for a fair reason. So if the employer can't get hold of the employee is not, can't move away from the fact that they still have to have a hearing, even in the absence of the employee, provided they've given the employee due notice of the fact that the hearing is going to take place on a certain day, a certain time, etc., and premises where it's going to happen. And call the manager, and it will take 10 minutes. It can be a very informal process. If you look at Schedule 8 when it comes to dismissal, a disciplinary inquiry does not have to be a very formal process because the Act takes cognizance of the fact that some employers, obviously most employers, majority are not lawyers. Yeah. You don't expect them to behave like lawyers. So you need to do the basics. Inform the employee, the employee doesn't turn up, have the hearing, call the manager in, the employee was contacted through a telegram or telephone call, etc., chose not to attend the hearing. You can proceed with the hearing in the absence of the employee and come to, the finding is one of guilt, come to an appropriate sanction. If it's absenteeism for 3 or 4 days, it can't be dismissed because it has to be progressive discipline. A warning, a final warning, and if the employee still stays away, then it can project to the next level where you can ask for dismissal.
Okay, viewers, time for our last ad break. We'll go on a break now. Please stay with us. Imtiaz will still be after the break, and if you then have any further questions, any comments, the number will be on the screen. Please call in for the last part of the program. Viewers, welcome back, and if you've just joined us, we've got Imtiaz Sirkot, Advocate Imtiaz Sirkot, talking to us about dismissal in the workplace. The topic was mainly about people who are being imprisoned, can't come to work. What does the employer do? What are the employee's rights? How do you deal with that? We've discussed that. If you have any questions, the number will be on the screen. You can call in. If you have any comments, please feel free to call in with your comments. We also going to talk now, Imtiaz, about what does the employer do? Because clearly the guy is away, and we've touched on that. But there was, for example, the Trident Steel case. Can you talk to us about that? What is Trident Steel? Do you go on paying the person? You don't pay the person? What do you do? How do you deal with it?
Look, the Trident Steel case is a labor court judgment, right? You must remember the payment of salary is based on contract.
Right.
The employee tenders his services, the employer pays him a salary.
Yep.
Now, because the employee is unable to tender his services, the employee has the right to stop his salary. The way to do that is for the employer to send the employee a letter to his last known address, saying that I'm stopping your salary based on the fact that you're unable to tender your services. And the labor court judgment in Trident Steel endorses that,
Right.
that the employer has the right based on contract to stop the salary immediately.
Okay. In common jargon, we say no work, no pay.
No work, no pay. You know, this has implications because what the employee would normally do, because the salary has been stopped, if the employer has a existing provident or pension fund, the employee would resign to access the pension or the provident fund. I've seen it from experience where it happens in many cases, that as soon as the salary is stopped, the first thing the employee does is resign to access, because one of the rules is if you want to access the provident or pension fund, you need to tender your resignation.
Right.
And that's what happens.
Okay, but Imtiaz, this raises other issues. Let's assume the employee doesn't want to go that route. Employee doesn't want to resign because the employee hopes to come back to work. Employer now stops the salary. Does the employer stop all deductions as well? I mean, there's pay as you earn, there's other deductions, there's, the UIF fund, but as you mentioned, Provident Fund, medical aid. Does the employer stop all that? Or?
No. What happens now, the employer has to make an election.
Right.
Either to terminate the contract of employment by way of dismissal. And the way to do that is to have a disciplinary inquiry. Well, sorry, not a disciplinary inquiry, the employee is in prison.
Right.
To write to the employee and give him the opportunity to make representations as to why his employment contract should not be terminated.
Okay, and then a bit of advice to employers out there, because now they're not sure if the person is coming back. They know now that when the person comes back, they need to hold a disciplinary hearing or an inquiry, even if it's not a disciplinary, because they need to give an employee an opportunity to explain why he wasn't there. It may not have been in prison, it may have been something else. It may have been the guy went to a traditional healer, it may be the person was in hospital lying in a coma, whatever the case may be, was out of the country, couldn't get a passport to come back. Employer now sits with the dilemma of having to hire somebody in that person's place because they can't. Production is standing. What is an employer? What advice would you give an employer in that case? How do they deal with that?
They can hire someone on a temporary basis in the employee's position. You see, the difficulty is we don't know the extent of the incarceration, whether the employee is going to be in prison for a few weeks, a few months, a few years. Let's assume the worst, that he's going to be there for a few years. Then the employer can immediately employ someone in that person's position, permanently.
Okay.
Right?
Let me stop you there again. We've got a call on the line. Assalamu alaikum, good evening. Go ahead with your question.
Assalamu alaikum.
Wa alaikum salam. Go ahead with your question.
What I want to find out from you is how many days after we get dismissed from the employment do we have to lodge a complaint with CCMA?
Okay, so can we just ask you to mute your TV at the back? There seems to be an echo.
Okay, hold on. Let me switch off the TV.
Okay, go ahead.
Hello, assalamu alaikum.
Wa alaikum salam.
What I want to find out from you is, tell me if I get dismissed, then how many days after that do I have time to lodge a complaint with CCMA?
You've got 30 days in which to declare a dispute at the CCMA.
And after 30 days left, we can't do
Sorry, just repeat the question.
if it's after 30 days, we haven't lodged a complaint, and if I want to do it again after...
No. You can... My advice to you is get the 711 forms that you require to declare a dispute. You can get it on the internet. You can download it, or you can go to the CCMA offices. They're very friendly, they're very helpful. They'll give you the forms, you can fill it in. And if you're outside the 30-day period, you're going to have to apply for condonation. You're going to have to give a reason as to why you declared your dispute after the 30-day period.
Okay.
So it's called a condonation.
What form?
It's called a condonation application because they have to condone the late application.
Okay.
Okay, but what was the reason for the dismissal, if we may ask?
You know, I feel it was very unfair because there was some people to work behind the back to try and wanted my position. So they decided to look for work like where I can do the work and so forth. And so they dismissed me on that basis. So that somebody wanted my job, so they went behind my back and spoke to the big bosses and they managed to get me dismissed, you know. And they didn't give me any written warning or final, just gave me final serious warning and then they dismissed me.
Okay, and when they gave you the dismissal notice, did they tell you that you have 30 days within which to apply to the CCMA or the bargaining council?
Nothing was said on that form. Nothing, absolutely nothing.
Okay, if they didn't do that, then that may strengthen your case when you apply for condonation.
Okay.
Because the employer does have an obligation, right, Imtiaz, to inform employees of their right to refer a matter within 30 days.
Do you know whether the employer has an internal appeal process?
No, according to the dismissal form, they never said anything about appeal, whether I got 7 days to appeal or maybe nothing.
Well, you know what you must do is try and get hold of a copy of the employer's internal disciplinary code and procedure. That will tell you whether you have the right to appeal. Because normally if they dismiss you, the letter of dismissal will say that you have the right to appeal within 7 days. And if there's no internal appeal, the letter of dismissal will say you have the right to refer the matter to the CCMA within 30 days of your date of dismissal.
But it doesn't say nothing of that on the form.
Okay, just be aware, right? Imtiaz, this is inform viewers. Employers do not necessarily have to have an appeal procedure. Don't misunderstand. Some employers do have an appeal procedure.
And others don't. Yeah.
Others don't. It is not a legal requirement. But if they do have an appeal procedure, Imtiaz, then obviously it needs to be.
Yes. Look, try and get a copy. They can't deny you a copy of the code and procedure. Check whether it allows for an internal appeal process.
And then I do have a case in case they didn't say anything about going to CCMA on the dismissal form.
Have they said you must apply to the CCMA within 30 days?
Don't say anything on the form that I have so many days to declare dispute or whatever it is.
Okay, then you need to apply within 30 days. And if you don't, and you don't have a valid reason because they did inform you of the 30-day rule, you can't say I didn't know about it.
They did not.
Oh, if they did not, then it'll strengthen your application for condonation.
Yeah, when you do your application for condonation, basically state the reasons. I wasn't informed, I'm a lay person, I have no legal knowledge of the labor laws and regulations, and I wasn't aware of the fact that I had to apply for 30 days. And then you need to give reasons as to why you think you have a very good case.
Okay.
Now, the commissioner would look at the fact.
So that I can maybe get some information as to how I can go about it.
Yes. The commissioner would look at the fact as to whether you have a very strong case. If you do...
If you to get your number so I can phone you, maybe you can give me some advice as to how I can write this letter out on condonation.
Phone ITV, they'll give you a few numbers.
Okay. Jazakallah khair.
Right. Jazakallah for your call. Imtiaz, we've got about half a minute, I think, to go. Just quickly, the grounds for condonation. Yeah. What is required?
Well, look, if it's a few days, normally commissioners would condone the application. Okay. If it's a lengthy period of time, like we're talking about 3 or 4 or 5 months, provided there's a balance where the employee has a very good case, and he can show that, that I have an excellent case, and the reason why it wasn't referred within the 30-day period is the following reasons. The chances are high condonation will be granted.
Okay, so the reason for the lateness they have to give,
yes, the reason for the lateness.
Whether they have a good case or not, and of course what prejudice there would be to either party.
Yes, that he would be prejudiced because he's unemployed, it's difficult for him to get another job, and his case deserves to be heard because he's got a good case.
Okay. What would be, for example, can you give us examples, or am I putting you on the spot? What would be possible examples for saying, I've got a valid reason for late dismissal? You can't just say, I didn't know. Yeah. That's not an excuse anymore, or could it be?
Well, you know, it could be an excuse. Yeah. It depends as to why it was late, for what reason. You know, some people hesitate to take the matter further. until they get legal advice, and then they believe they have good case.
Right.
And then they want to declare a dispute. So what I'm saying is if it's a few days late, provided there's a balance and there's good prospects of success on the facts of the case, continuation would be granted.
Okay, so the applicant will have to show, I was late by so many days and this is the reason why I'm late. The applicant will have to show, this was my case, I was dismissed for the following, I believe it is unfair for the following reasons. Give some reasons why, so that the commissioner can look and say, maybe there was an unfair dismissal. And then, of course, there's the prejudice. What is the prejudice to the employee? What is the prejudice to the employer?
Yeah.
And usually, employer will say there's no prejudice to the employer.
Normally, the prejudice is on the side of the employee because the employee is dismissed.
Right.
The chances of getting another job are very slim. So the prejudice is on the employee side, not the employer.
And the applicant usually says, you know, it needs to be heard by an independent person.
Absolutely.
I haven't had that opportunity.
Absolutely.
I will be denied that opportunity.
No, absolutely.
Okay. Imtiaz, we've come to the end of the program, and I need to say, you know, Jazakallah for you. We've spoken about what happens when somebody is imprisoned, how do they deal with it. You know, obviously, just one final one before we close off. Can the employer not say the employer has brought the company's name into disrepute, if it is a criminal case?
Yes, to a large extent.
Right.
In fact, that forms the foundation of some disciplinary inquiries.
Yeah.
That you brought the company into disrepute and therefore the trust relationship has broken down completely, you should be dismissed.
Okay. Or
That's
if the
what normally
employee was dishonest somewhere, stole something somewhere, was involved in a robbery and works in a position of trust, the employer could use that as well.
Yes, it impacts on the operational requirements of the business, and therefore the employee would say that the trust relationship is no longer there and the employee should be dismissed.
Because that, even if the misconduct is not in the workplace, misconduct is elsewhere, but it impacts on the employment
on
relationship.
the business of the employer.
Okay. Viewers, Imtiaz, Jazakallah, thank you for making yourself available, and inshallah we'll have you on another time because you saw there were a lot of calls. I think we haven't exhausted this topic. We need to make sure that we get you back in again. Viewers, we've come to the end of the program today. Inshallah, I hope it was useful for you. We'll be back next week with another edition of Legal Ease, so join us next week at the same time on ITV.